Good morning, ladies and gentlemen. The Honorable Chief Guest, Mr. Arun Jaitley, Justice A.P. Shah, the Chairman of the Law Commission, Professor Sri Kumar Banerjee, Homi Bhabha Professor and former Secretary of the Department of Atomic Energy, Mr. Uday Shankar, who is a member of our board at the Vidhi Centre for Legal Policy, distinguished speakers, ladies and gentlemen. My name is Orgo Sengupta and I'm the Research Director at the Vidhi Centre. I'd like Uday to come and formally welcome Mr. Jaitley and give you a brief idea as to what's going to happen today.
Thank you, Argyo. I stand here before you not because I'm qualified to comment on the subject. I'm absolutely not, actually. But as a media person, I've been troubled by the debate that's been going on in mainstream media, including social media, on the subject. The absence of facts and knowledge among many of those who have spoken on the subject makes rumor mongers appear credible. And that's why Vidhi's work is so desirable and so admirable. I'm here to compliment the work that Vidhi is doing at a time when we seem to have legitimized the divorce of facts and authority from public discourse. The work that this group of brilliant, erudite, and focused lawyers are doing tells us that there might still be some hope for us. That also brings me to my second point. I'm also here to thank and compliment our chief guest, Mr. Jaitley, for agreeing to be here today, despite a very pressing schedule. Thank you for being here, all of you. Thank you, Mr. Jaitley. Nargya, over to you now.
So I'll just briefly give you an overview of what the report that the Vidhi Centre for Legal Policy has produced, titled Operationalising India's Nuclear Agreements, is about. Because Vidhi as an idea was born during 2010, at a time when the Civil Liability for Nuclear Damage Bill was being debated in Parliament. And we were doctoral students at Oxford University then and felt that some of the key legal issues were being missed in the public debate at the time. What started with an unsolicited submission to the Standing Committee of Parliament has come some distance today, where we are now a full-fledged legal policy think tank with lawyers all committed to ensure that we have better governance through better laws. The issue of nuclear liability, and specifically the Nuclear Liability Bill, as Uday just pointed out, has been particularly fraught for the last few years. In the life of a legislation, this is not extraordinary. I think the moment is opportune now for us to look at this issue closely, debate solutions as to what could be the way forward with regard to nuclear liability law in India, and this is precisely what the report proposes to do. We've dealt with two key issues, that Section 17, which is the right of recourse against suppliers, and Section 46, which is concurrent liability against suppliers, which seems to be the major stumbling block to the operationalization of India's agreements. Through this report, it is not as if we present that we have all the answers. Far from it. That's why we have the roundtable today, because we realize that our perspectives are primarily legal, and I'm hoping for a multidimensional discussion today with varied perspectives from the eminent speakers who we have speaking at the substantive sessions of the roundtable itself. With that, I'd like to invite our chief guest, Mr. Jaitley, together with Justice Shah, Dr. Banerjee and Uday, to formally release the report. Thank you very much. I now invite Mr. Jaitley to come and say a few words.
Justice Shah, Dr. Banerjee, Shri Uday Shankar, Aragya, ladies and gentlemen. I today suffer from a limitation as to how much I can speak on this, for obvious reasons. I told Aragya yesterday that I'd agreed to come essentially because of him. I have known this young gentleman now for a few years. I came across him when the nuclear liability law was being legislated. My colleagues who were members of that committee told me that they'd started receiving briefs from a young student group in Oxford, and they would travel to India at their own cost brief members of parliament as to what the possible law could be. There have been various comments, and what eventually is going to happen, really that's the reason I said there is a limitation on how much at this stage I can speak. But I'm quite certain that this workshop, in discussing the possible roadmap, or in at least retaining or altering what's there, will certainly play an important role. And I'm sure there would be a lot of them material outcomes of the day-long discussion which Vidhi has organized today. It would be of extreme use in educating some of us as to what possibly is required at the moment. Thank you, and I wish Aragya and his entire team the very best.
Thank you for that, Mr. Jaitley. If I could request Justice Shah to give some introductory remarks on this topic.
Mr. Arun Jaitley, Dr. Banerjee, Mr. Uday Shankar, Mr. Arghya Sen Gupta, very good evening to all of you. First, let me thank Arghya for inviting me for this discussion on the Civil Liability for Nuclear Damage Act 2010, CLND Act it is shortly called, and the Civil Liability for Nuclear Damage Rules 2011, it is, we'll call it CLND rules. When Arghya asked me to participate in the discussion, I told him that I'm completely opposed to the entire idea of the use of nuclear energy and have all along been against it. I have in fact personally involved against the setting up of nuclear plants in places like such as Jaitapur, Kudamkulam. In my view, nuclear energy is neither safe nor entirely clean, nor it is as cheap as it is often projected. But leave aside that, Mr. Sengupta said that at least I should speak on the legal aspects of it. And I therefore agreed to address this issue because I found that there are serious defects in the Act. I mean, I examined the Act very dispassionately, and I just wish to present before you the problems which are very apparent in the implementation of the Act. It's a very sensitive subject, as the Honorable Minister has pointed out, that it's very difficult to even debate on these issues. And I was told that even the existing plants are under problem because of this law. Because if you want a supplier to do something in the existing plants, then his liability will be unlimited, even of the Indian supplier. So it's going to create a problem. I feel that one should have a complete relook at the Act.
Thank you, Justice Shah, for those introductory remarks. It's wonderful that we have people of all different dispositions, people who are for nuclear energy, against it, and that's the purpose of the round table, to try and discuss and debate solutions that satisfy, or at least try to satisfy, as many constituencies as possible. And thank you once again for coming. Thank you very much, ladies and gentlemen, for staying for what is the first substantive session where we will be going into the depths of the report in a manner that we haven't been able to so far. So I'll quickly run through our panelists in this session. Justice Shah, who you've already heard, the Chairman of the Law Commission of India. Mr. Ronen Sen, a distinguished career diplomat, long-serving ambassador to the United States, and also the Secretary of the Atomic Energy Commission at a very trying time. Professor Rajaraman, Emeritus Professor of Theoretical Physics at JNU. Dr. Grover, the director of the Homi Bhabha National Institute and a member of the Atomic Energy Commission. Mr. Rakesh Sood, another distinguished career diplomat who served as ambassador to many countries, including France, and has been most recently the former Prime Minister's Special Envoy for Non-Proliferation and Disarmament. Mr. Y.S. Trivedi, Executive Vice President, Heavy Industries from L&T. I'd like to invite Mr. Sen to present his opening remarks. Thanks very much.
I would like to just make some brief observations. based on the experience, not only in the United States, but in Russia, where I served much longer, and elsewhere also in Germany and the United Kingdom to a lesser extent. But primarily for about 6 years in the Prime Minister's office, specifically dealing with issues relating to atomic energy, space, and some defense and other sectors. What I feel is that also that one aspect which we should take into consideration, quite apart from the legal aspects, is what is our objective? The liability law, of course, it has to meet some of the basic things. We'll have to get it in terms of the humanitarian aspects. We have to address them. But what is our overall objective? Is it to remain permanent importers?
There are people in this table who know that 22 reactors have been built completely with the Indian industries together. I'm speaking on behalf of Indian suppliers. Now, let's look at that. What is the situation for Indian suppliers? See, the way I see the Act, it actually probably relates to a turnkey supply where the whole technology and the complete plant comes from outside, and then of course you make the supplier take the liabilities. Or on a BOT basis where it is build, own, transfer. Now in this specific case, whereas in case of India it's completely different. The design is by NPCIL, the engineering is done by NPCIL, specifications are for NPCIL. The Indian industry is actually an entity which does build to print.
Now coming to the substance of the report, I'm generally in support with what the report says and its recommendations. Now let me come to specifics, and I'll start with some of the things that I strongly agree with. I'm afraid I'm going to be speaking not so much as a scientist, but as a person who read your report. So first of all, I agree that the inclusion of supplier liability through Section 17B is, generally speaking, reasonable. So instead of being apologetic about including supplier liability and thinking of ways to amend the Act to get rid of it altogether, not that that's politically ever feasible, but even we shouldn't even think about it, I think we should find a way of keeping some supplier liability in, but with reasonable mitigating modifications, taking into into account all kinds of things, multiple inputs into the object, sub-suppliers, subcontractors, repairs, later inputs. All this has to be spelled out a little bit more.
Let me start with what you've said in your report, which I think is very valid. You've said that the way forward has to be in terms of constitutionality, in terms of a coherence of, because as I think Justice Shah also pointed out and others have said, at the present moment there are inconsistencies, and your report also tries to bring it out. There are inconsistencies in the existing legislation and the rules that derive from it. And we also need to make our legislation, which is 2010 vintage, more in tune, more contemporary. And I think that's a key point. The fact that supplier liability did not exist in the early years, in 50s and 60s and so on, does not mean that today it will not. There have been many evolutions in public goods and supply of public goods and so on. Environmental law, polluter pays principle, etc., all of which require that supplier liability is an idea which may not exist in treaty terms, but it is certainly an idea whose the spirit of the idea is something whose idea, the time has come for it.
Let me start by saying that whatever I'm saying in my personal capacity, and I'm not a lawyer. And so my views will have a technical bias. We can take one example of a shutdown cooling pump, which is a system important to safety. It is NPCIL who decide the flow rate and the head to be developed by the pump. Any issue arising from inadequacy of the flow rate or the head is the responsibility of the designer, that is NPCIL. It has been argued that something like a shaft seizure of a pump can result in a failure, and for that supplier has to be held responsible. I think this argument overlooks the basic design philosophy that no single failure can cause a nuclear accident, and in case system designer has overlooked this vital fact, then the fault is with the system designer and not with the pump supplier.
Who is the supplier? I mean, that's really a matter of contract. I mean, but that can be a provision in the rule, clarifying this position that this could be a matter of contract, etc. But there has to be a supplier finally. The parties may determine by agreement that who should be termed as a supplier if there is a joint supply or several parties are involved. But I agree that but still the issue remains that the 24 exceeds or goes beyond section 17.
What was the purpose of CLND Act? If you just ask the question that why the CLND Act came up. Dr. Grover gave a historical background, it's very important. But the most important thing was that whoever is the victim of a nuclear damage should be compensated at the least amount of time without any prolonged litigation. That is the purpose. So how does it, as a technologist, I would say that we would never, we hope and we also wish that never this kind of an act comes into real action, because system should be safe enough not to have that. In fact, the CLND Act is to make a single party responsible for the compensation process, and that is only the operator. There has been debate on this, that eventually the operator can be a private, but this discussion, even in the Parliamentary Standing Committee, came to the point that that is something of future, and today we are talking of only government company or government itself being the operator.
Please join me in thanking all the panelists today for a very illuminating discussion.
Our speakers this session, joining us from Oxford via Skype, is Dr. Anupama Sen, also a co-author of this report and Senior Research Fellow at the Oxford Institute of Energy Studies. We have with us Dr. G. Balachandran as well, Consulting Fellow at the Institute for Defense Studies and Analysis. Mr. Gopal Jain, Senior Advocate at the Supreme Court of India. Mr. Kaustubh Shukla, who's here in his capacity as both Secretary of the Indian Atomic Industrial Forum as well as Chief Operating Officer at Godrej and Boyce Manufacturing Company. And Mr. Siddharth Vardarajan, journalist and academic and currently Senior Fellow, Center for Public Affairs and Critical Theory at the Shiv Nadar University. Over to you, Dr. Banerjee. Joining us today, Mr. Shilkant Sharma, former Indian Ambassador to Austria and Permanent Representative of India to the UN and the International Atomic Energy Agency. Thank you, sir, for joining us.
So, welcome to the second session. And as you are aware, this is on concurrent liability under other legislation of operators and suppliers, including questions of insurance. Go over to first to Dr. Anupama Sen, who is speaking from Oxford, and is through the Skype.
So thank you, Dr. Banerjee. I would like to focus on part 4 of the report, which specifically talks about the issue of liability and costs. And I'd like to begin actually by addressing a question that I noticed came up from some of the respondents to the draft that we had circulated, which is why include this discussion on liability and costs in this report, and how does it relate to the other provisions that have been discussed in other parts of the report. And to my mind, there are two issues that frequently arise in the entire debate on nuclear liability. The first one is, will onerous liability requirements on operators and suppliers lead to an increase in the cost of nuclear power? And the second issue is then the question of whether the amount of effort that needs to go into operationalizing nuclear energy is actually disproportionate to its eventual contribution to total primary energy supply.
I wanted to mention that this confusion between safety and safeguards is very damaging, because we would like to get, in India at least my understanding is that the DAEs would like to get safety-related inspections from IAEA, yes, and already they have been taking place. But in the public mind, they get confused. Then a safety-related inspection, which was thought in the 1990s by WANO, was misjudged by our parliament, saying, oh, you're opening for safeguards, and then, answering at a different level. So because of that, it's not good to confuse these things.
First question comes in that notwithstanding these difficulties, CSE has a provision, Article 22, which says any state which has a liability law which is not in agreement with the annexed will cease to be a member of CSE. And there may be a doubt, and I think there are certain American lawyers, that's why they want us India to ratify it, because they can challenge it. India doesn't want to ratify it, I don't know for what reason, so we can take it. But the point is this, that equally likelihood of Indian membership in CSE, if it ratifies, being declared null and void. Question is, should that make any difference to the US liability law or the US suppliers? Now the supplier's main problem is unlimited liability for unlimited period of time. That can never stand place in anywhere. No commercial firm will ever accept. And those who say have never run a firm, it's like Upanishad says, those who know don't talk and those who talk don't know. Those who talk about unlimited liability, etc., have never run a company, and those who run a company never say, I'll take an unlimited liability.
India has a nuclear policy. India has agreements for use of nuclear energy. But these are active and not dormant, inactive and dormant. And that raises the question as to why that is so. Obviously, one of the reasons, as the topic itself suggests, that the framework of the Act is such that it suggests that there is possibility of liability being imposed under other legislations. And that certainly is one viewpoint which I will show you from Section 46 of the Act. But another which is equally important is really the role of the superior courts in India, that is the High Court and the Supreme Court, who not only have the power of adjudication, but they have what is called inherent powers, that is, the powers to do complete and substantial justice, and therefore they can always mold the relief in any case. And that, under the constitutional scheme, was felt that they needed to be given those extraordinary powers to be able to bring relief to some person or any person who claimed that injustice had been done.
There is kept, so 46, I would say, preserves the right of the Indian citizen to invoke law, to claim damages, if and when the executive authority fails them. And I don't think we need to be apologetic about it, and I don't think companies need to worry, because this has to be proved in a court of law.
Chairman, sir, I have lost my voice. I guess, the prospect of unlimited and unending liability is playing on me. I thank Gopal Jain for the comforting words to restrict the concurrent liability. Otherwise, I would have been lost for words. I think being the beast of burden, because finally the suppliers are supposed to be open to risk, I would request some more time. I think rightly pointed out that context should not be missed. And my fear all along since the discourse, why now? For the past 4 years, we as engineers, we have been only discussing legalese, something that we don't understand. We haven't focused on how to produce better product, how to be more productivity, how to produce a greater reliable equipment. And that's the unfortunate part. For last 4 years, we have maintained infrastructure, people, capabilities that have really gone down the drain. And today we are straining. The prospect of being open to recourse, I mean, I'll come to the concurrent liability. Of course, that's a relief, and I agree, Aragya, in your report, the recommendations that you have said that go easy on the suppliers for the concurrent, I welcome that. But even the risk of recourse is, according to me, unjustifiable.
The culmination of this event would remain incomplete without acknowledging the role of certain individuals, and hence it is only befitting that I end the Vidhi Roundtable for Operationalizing India's Nuclear Agreements with this vote of thanks. On behalf of the Vidhi Centre for Legal Policy, I would like to convey my heartfelt gratitude to our speakers who've presided over both the sessions. It was indeed enriching to have had such distinguished panels of speakers today with us, enlightening us on a subject which admittedly requires immense expertise.